We're about to watch a case that I think illustrates the corruption in the Louisiana DOC. Richard pointed this out. There are news articles. We're going to go over all of them. But first, let's just jump in and watch the first hearing, and we'll go from there.
All right, ready for our next case.
This is the case for Bobby Snead, DOC 81275. We have Carrie Myers, Louisiana Pro Project, who will be speaking. Jane Hogan, LSU Law, who will be speaking. And we have Norris Henderson, representative with family member, Charles Snead, who's a friend.
All right, thank you. Please introduce yourself, state your name and DOC number for the record.
Bobby Snead, 81275.
Bobby, my name is Brendan Kelsey. Along with me is Mr. Tony Marabella, Mr. Victor Jones, Mr. Jim Wise, and Ms. Pearl Wise. Will be your panel today. I'll explain the process to you. We'll read some information to the record, have a parole interview, ask you some questions. You can respond at the end. You can make a statement. We'll take a vote. You understand the process?
Yes, sir.
Bobby Snead, DOC number 81275, first class offender. Parole eligibility date 8/1/2017. Not eligible for good time, full term life, second degree murder. Sound correct?
Yes, sir.
You tell me how old you are, Mr. Snead?
I'm 74 years old.
How long have you been incarcerated? How many years?
This coming June will be 47 years.
And tell me when your last discipline was. How long has that been back?
I was in 2016.
You remember what it was for?
From tobacco.
What are you currently? Are you a trustee there?
Yes, sir.
Class A?
Class B.
What do you do? Do you do any work or anything around the facility?
I'm inmate constable.
You make okay. What you've had a lot of time down. Have you taken any classes?
Yes, sir.
Done anything in particular?
Well, I did Thing for a Change, 100 hours, substance abuse, some spiritual classes.
Sure.
I taught a lot of classes.
Okay. What'd you teach? You help teach some classes or tutor some classes?
Well, we when I was president of the Lifers, we sponsored the first law class, and I also taught a music theory class.
Okay. You have a GED?
No, I have 2 years of college at Grambling.
2 years of college. Okay, so you got your high school diploma and then you had 2 years of college?
Yes, sir.
Grambling. Well, looks like you've been involved in some sports too. Look, coach of the year. That's pretty impressive, huh? Been a coach of the year. Basketball, softball.
That's what I do. Yeah.
That's what you do. So did you play some of those sports or you just coach them?
I played and coached.
I got you. So what obviously your plans looks like you got the parole project here. I assume your plans will be to go to the parole project and go from there. Is that kind of what you got on your mind? What are you thinking if you were,
Yes, sir.
if you were released early? What's your plan?
Well, I want to go with the project, and we'll go from the project to New Orleans and get with Norris and my little brother, and we're gonna go from there.
So ultimately, you're trying to moved back to New Orleans.
Yes, sir.
And that's what your little brother, you said?
Yes, sir.
Warden, you got some input for me?
We just got Bobby, I did hear him say that he 47 years, we got him down for 33, so I'm not real sure. We got him as coming Angola at 87.
No,
But other than that, he's been a trustee, he's an inmate council, and he's done all the classes that he needs to. This is one to one there, by the way. Other than, had write-ups, his contraband has all been like cigarettes, nothing serious. So that's about it on this end.
Yeah, I was wondering about the years as well. I had 87.
well, I can explain that.
Go ahead. Yes, sir.
I got a new trial in 86. And I went back to trial and I came back to Angola in 87. But I've been down since 1974.
74, that's right. Okay, that makes more sense. Okay, sounds like you've been working hard, doing a lot of good things.
Oh, yes, sir.
Trying to put in the time and do what you can do. Like I said, I don't have any more questions for you. I'll sit back, see if anybody's got anything specific.
Thank
Mr.
you.
Marabella,
I don't have any questions. Thank you very much, Chairman.
Mr. Jim Wise. Got to take you off of mute.
I don't have any questions.
All right, Ms. Pearl Wise.
Sir, I see you got some graphic communications and graphic tech certification. What are you planning on? Graphic arts. What are you planning on doing with those?
At age 74, I really can't do a lot. I got a Vietnam Agent Orange claim, and
Okay.
so I'm just gonna,
Go rest somewhere.
that's right.
Oh, okay. I thought about that after I asked, but I said, okay,
Yeah.
well, let me go and ask. See what he's gonna do.
Yes,
Now, do you have any children? Yeah, 4 children, right?
Yes, ma'am.
What kind of relationship do you have with them?
Good.
What are their ages?
My baby is he should be,
This around about age.
well, he should be 49.
Okay.
And my oldest child is my daughter, and she should be around 51.
When y'all need to go ahead. I'll just drive over.
Okay.
Hey,
All
Jim,
right.
we can hear you, Jim. There you go.
Okay. And you are you a great grandfather?
Yes, ma'am.
Okay. All right. Of how many?
I don't know, about 12, I think.
Okay. All right then. That's all I had, Chairman.
All right, Mr. Victor.
I don't have any questions.
Great. Mr. Kerry Myers, would like to make a statement?
Thank you again, and good afternoon, Kerry Myers, Louisiana Parole Project. As Mr. Snead has said, he served 47 years. He's now 74 years old. He's also a military veteran, served in Vietnam. I bring that up not only for his service. He was in college. He was drafted while he was in college and ended up serving in Vietnam. I bring it up also because we're going to assist him with the VA through the VA services once he is released. So Mr. Snead's income will probably, and so he'll have support through Social Security and VA assistance based on his Agent Orange issues. After he comes to Parole Project, of course, we're going to work with Mr. Snead through his position. We'll provide him the transitional services he needs. We'll make sure he has his health care set up. We'll make sure that he has any other benefits that he's entitled to. We're also going to give him instructions and social norms. After 47 years, obviously, that's going to be a major issue. Consumer skills. Mr. Snead is you said, he has some college education. He's been a counsel, can function at a plus going into another support with First 72 in New Orleans, Mr. Henderson and his brother. So Mr. Snead is got a continuity of support that we know that that he will be well taken care of. He'll also end up being a mentor for younger people who are coming out. Based on his experiences and his skills, he'll be an excellent mentor. So we obviously are prepared to assist Mr. Snead and work in anything he needs in his transition. Thank you.
All right, we'll hear from his brother or Norris, whichever one of you guys can speak.
Yeah, we all here. I'm named Norris Simpson. I'm the executive director and founder of VOTE, and also founding member of the First 72 Plus. His brother Charles is right here behind me, who is the case manager at First 72 Plus. We have a few other friends, Earl Trouvier, Checo Yancey, and Kenny Johnston, and someone else, and Wayne Thomas. Also, on one of the biggest problems this morning was the family is so big, we couldn't get everybody on the call. So he has 2 sons and a daughter that's on YouTube. He has a grandson, 3 sisters, 3 brothers, and a niece that's on YouTube watching. When somebody was asking, I think with Mr. Kelson about sports and his being in sports, what he didn't say also is that sports run in the family, because he has a grandson that plays for the Kansas City Chiefs. And so he definitely has not only family support, he has our support. He have Kerry and Andrew and them in Baton Rouge to kind of get him jump started. And he got me and his brother here in New Orleans to kind of like that wraparound services that he need once he leaves the First 72. We've been knowing Bobby for the whole duration, and just would really be a blessing to all of us, not just us in this room, but to his family that's online watching to be a part of this any event that the board votes to grant him parole.
All right, thank you. All right. You'd like to make a statement on your behalf, Mr. Bobby?
Well, I just want to say that my deepest remorse goes out to the victims and my family. And I want them to know I'm sorry, and please give me another chance.
All right, thank you. We'll hear from Ms. Hogan. Wrap it up, please.
Thank you, Mr. Kelsey. Jane Hogan on behalf of the Parole Project and Parole Clinic. I will make this very short. As you heard from everybody here, Mr. Snead is an excellent candidate for early release. He served this country in Vietnam when he returned in 1968. He probably could have used counseling and services for the trauma that he experienced over there, which then led to his incarceration. He spent 47 years nearly, and since incarceration, he's been active in different organizations, active in sports, and the only thing that wasn't mentioned is that he was actually instrumental in creating a dorm, an honor dorm at Maine Prison, specifically for vets. And so Mr. Snead is an excellent member of the incarcerated vets. He created the honor dorm. He's been a C-class trustee since 2010. And even though he suffered a stroke in 2005, which caused him to have to relearn to speak and use parts of his body, he is an extremely hard worker. Since COVID, he's been working about 16-hour days doing rounds as a legal counsel substitute at the state penitentiary. He goes to the cell blocks at night. He's running around Maine Prison during the day. He's doing DB court. He's an extremely hard worker. He will be an asset if he is returned to his family and his community. So we would ask the board grant his parole today. Thank you.
Thank you. Panel prepared to vote? I'll vote first. Bobby, I vote to grant you parole today. You've done a great job, worked hard, you've done all the things you needed to do. I would vote with stipulations for a curfew from 9 p to 6 a. Once you go to the parole project, curfew 9 p to 6 a. You'll have report to your parole officer for the first 60 days weekly. You'll have just general counseling evaluation, just an evaluation, and that includes some mental health evaluation. Just to have a good evaluation process, that would be good. I want you to do community service 6 hours a month, and you have no contact with the victim's family. And I think that's it. Congratulations. It's on my vote. You did a great job, and hopefully you do well.
Thank you.
Mr. Marabella.
Thank you, Mr. Chairman. Mr. Snead, I just want to say you've done a lot of hard work. This crime was a bad crime, as most of them are that we see. But you have done remarkably well while you've been in prison. I likewise would like to thank you for your service. Perhaps I'm in a better position than anybody else on this board to say that you're a young man, because we're 3 months apart. I noticed your birthday is in December and mine is in September. I consider myself a young man, so I consider you to be a young man. I was one of the few that avoided Vietnam. I was in school when all of that happened. I appreciate your service, and it would be my vote as well to grant your parole today. So good luck to you, sir.
Thank you.
Ms. Perlwise.
Mrs. Snead, my vote is to grant as well, for the reasons already been stated on the record. Best wishes to you, sir.
Thank you.
Mr. Vic Jones.
Mr. Snead, I want to also thank you for your service in the military, and thank you for making the best out of a bad situation where you find yourself. And my vote today would be to grant also.
Thank you.
Mr. Jim Wise.
At this time, I vote the same. I vote to grant. Today you've been granted.
All right. Yes, 5 votes to grant your parole. Your parole's been granted with the stipulation stated. Good luck to you.
Thank you.
And it's 1:48, Monday's 3:15. Will.
Now you might be asking yourself, well, where's the corruption? What are you talking about, Mandu? But don't worry. We have another hearing that takes place just 2 months after this hearing, where he got 5 parole board members to grant his parole, which I don't think I've ever seen before, because they were probably doing commutation hearings today, and they happened to slip him in, and they had 5 board members. If you're curious about what he did, and you're wondering if 44 years, and really, I mean, if you've seen anyone that is deserving of parole, in my opinion, of all the hearings that we've seen, he's on the top of the list. And I was hoping, when I looked over the information, that it wouldn't be a terrible crime. It was a terrible crime, but his involvement. So let's first start on, and then we'll go to the second hearing. During the early morning hours of June 13, 1974, Curtis E. Jones and his wife were attacked as they slept in their home in Gippsland, Louisiana. The elderly couple was beaten, bound with wire, robbed for $700, which in 1974 is, I don't know, is that $5,000? After the attackers left, Miss Jones was able to loosen her bond and summon help. But by that time, Mr. Jones was dead as a result of the injuries he received. And yes, that is a horrific crime that you should get life in prison for. But here's the caveat. There were 6 men involved in the crime, and he was never even went into the house. He was a lookout. And so that makes a big difference. It is easy to believe that he did not have any expectation of that happening. He was outside the house. He didn't see it happening. And to have served 44 years after being sent to Vietnam, where he picked up Agent Orange and went through who knows what, and then in prison really seems to just completely excel, and even after a stroke is still, and all of those things. So he gets the parole. And then what happens? We have, by the way, we have like We're going to go through a lot here, so hang in with me. But first, let's go to, for some reason, another hearing that takes place just 2 months later.
Good morning, Thomas Frampton, on behalf of Bobby Snead.
Okay. Let me explain the process to you. First, I will read information into the record, then the board will conduct a parole interview with you. At the end, you'll be allowed to make a brief statement before the board votes. Do you understand the process?
I apologize for interrupting. I do have some procedural concerns that I'd like to raise at the outset, if possible. There are two specifically. The first is regards communications that I sent to the board on Friday about how we got here, essentially, whether a parole hearing is proper in this context because of a procedural irregularities with respect to the purported rescission on Friday. And the second was a request that I filed for an opportunity for a continuance. We learned about this parole hearing on Friday afternoon. I want to apologize to the committee for my dress, but I haven't had the opportunity to speak with Mr. Snead, to call witnesses, to familiarize myself with the record, or to otherwise obtain the documents that would be necessary. But I think before we even get to the request for a continuance, I'd like to, if it pleases the board, to address the threshold issue.
Mr. Frampton, I don't want to interrupt you, but I'm going to. My name is Tony Maribel. I'm chairman of this committee today. We are going forward with this is a rescission. This is not a parole hearing. Your client was granted parole a while back. 10 days later, he violated conditions by committing illegal acts, and we filed for rescission, and that's what's happening today. We got all of your information on your continuance. You were not attorney of record until earlier today, as I understand it. You had explained that you weren't going to be the lawyer. You weren't sure you were the lawyer at that time. We've made arrangements. You are here on the phone now. This proceeding is going forward today.
Thank you, Chairman. And just to clarify, I've been attorney of record for Mr. Snead since March 25th, when I notified the secretary as much in writing. And I apologize to the board. I was actually informed in writing that today's matter was not a rescission hearing, that in fact had already occurred, and that today was a new parole hearing. So if I misunderstood that, I apologize if that was mistaken. That was not the information that was provided to me by Executive Director Abbott.
Okay. Mr. Frampton, Alvin Roche, good morning. Mr. Frampton?
Frampton, sir, good morning.
Frampton, okay, I'm sorry. Mr. Frampton, my name is Alvin Roche. This is a rescind hearing. It is a parole hearing, but it's a rescind hearing simply because Mr. Snead had been granted earlier this year, and there were some circumstances after he was granted that caused us to rescind our decision. This is a parole hearing to address that matter.
Understood, sir. And I appreciate that. If that is in fact the case, the first issue, I believe, before the panel would be whether or not under Board Policy 05-505-POL Section M, which governs rescissions, this hearing can go forward. Particularly, that section which governs rescissions requires first, before any hearing, that the Secretary of the Department of Public Safety and Corrections must notify the parole board. That notification requirement serves a sensible and essential function. It prevents the board from acting based on unverified and untested allegations, and critically, it prevents the board from acting sua sponte, where the secretary's own administrative process has determined that the offender did not engage in misconduct. In this case, I represented Mr. Snead before the disciplinary board at Angola on Wednesday, May 6th. And after a 3-hour hearing, the administrative hearing determined that Mr. Snead, in fact, did not engage in any sort of misconduct.
Mr. Frampton, the secretary himself never makes those recommendations. It is a representative of his, and that was done in this case. This is not a disciplinary hearing. This is a rescission hearing, and we're going to go forward. You've made your statements, you've made your concerns, we're moving forward.
Mr. Mirabella, if I may just very briefly make my record, when I spoke with Executive Director Abbott, he initially indicated that no notification was required. I've subsequently learned that he's represented that Deputy Warden Falgo provided the notification required by 505M, and that an affidavit had been executed by the secretary. Over the weekend, I spoke with the general counsel for the secretary, asking for all affidavits that delegated that authority. In fact, the secretary has delegated authority by affidavit to various officials at LSP for various matters. But critically important, he has not delegated the authority under 505. And that's the concern here, is that the secretary has not delegated that authority to any member who's made a notification to the parole board, because in fact, the secretary's own process has determined and exonerated Mr. Snead of any alleged wrongdoing.
All right, Mr. Frampton, you've made your record. We're moving forward.
At this time, then, Your Honor, I'd request, I apologize, members of the board, I would request a continuance. The reason I would request a continuance is if this is in fact a rescission hearing, we've repeatedly requested to receive any copy of whatever notification or other information this parole board has received. We believe we're entitled to that under Section 574.12G. And I would like to have the opportunity to present that information to the board. I've also been requesting Mr. Snead's healthcare records nonstop, essentially since March 25th, and I have not been allowed to obtain that by the Department of Corrections, despite Mr. Snead executing a HIPAA waiver.
This hearing is very simple. Your motion for continuance is denied. There's one issue before us today, and that is what happened on March the 25th.
And specifically, if given even a slight continuance, I could provide this court with a 3-hour record of the administrative hearing where that was litigated at length.
Administrative hearing, Mr. Frampton, we're going forward today. You've made your statement, and I appreciate it. Your record is clear. Now we're moving forward with the hearing. Does your client wish to talk?
If the board would allow me to speak for him, I can explain what happened on the 25th.
I'm going to ask him some questions. That's not the procedure.
What would the board permit me even 2 minutes to meet privately with Mr. Snead?
If there's some way of doing that, certainly. Where are you?
Through a breakout room on Zoom. I'm in California. I would have been back in Louisiana if I'd gotten notice before Friday afternoon that this was happening today.
Possible to give you a few minutes?
Teresa, if you could, please place Mr. Frampton and Mr. Snead. LSP, you all may have to excuse yourself out of the room just to give you attorney-client privilege.
Okay, all right.
So they gave him almost exactly the 2 minutes. And yeah, so if you can believe it, well, let's just continue to watch it through and then we'll unpack it in more detail. But it's truly only in Louisiana.
Okay, we're ready to proceed. Mr. Snead? Mr. Snead, you're serving a life sentence for the murder of Curtis Jones. You've been in prison for 47 years. Is that correct?
Yes, sir.
Mr. Snead, the parole board held a lengthy hearing on March 15th of 2021, hearing both support and opposition, and recommended parole with certain conditions. You recall that?
Yes, sir.
10 days later, you were found unresponsive. CPR was administered as well as Narcan. After medical intervention, you were breathing and transported to the medical center, at which time, while at Lane Memorial Hospital, part of your admission to the Lane Memorial Hospital, as part of your history of what happened, you indicated to them that you had injected heroin earlier in the day. Is that correct?
No, sir.
Oh, you didn't say that.
No, sir.
You didn't inject something that you thought was heroin on that day?
No, sir.
You did inject methamphetamines, didn't you?
No, sir.
So you're denying what you told the medical record.
I was unconscious. I don't even, I didn't tell the medical record anything.
Mr. Snead, you were transported breathing to Lane Memorial Hospital, at which time you were interviewed by the doctors and the medical staff there, and you indicated to them that you had injected heroin earlier in the day, and you later tested positive for both methamphetamines and amphetamines.
No, sir.
You didn't?
No, sir.
That's what you're telling us today? The records indicate otherwise?
And I'd have to object again. We have no idea what records the parole board is referring to. We've repeatedly asked for them again and again and have been denied by prison authorities and by Executive Director Abbott. So I'd ask, but if the board would like Mr. Snead to respond to specific allegations that we have notice of what information is.
I just asked him the specific questions and he has denied them. This is a discretionary hearing within the realm of the board. And let me tell you, Mr. Frampton, if this would have occurred 10 days before the hearing instead of 10 days after the hearing, the vote would have been different, as likely it will be today.
And I have some additional information that I think might affect that determination, because I don't believe the information the board has received. And again, I'm guessing because I don't know what information you've received is fully accurate.
We have hard facts that we're relying on today. Now, your client has denied all of these things, and we accept that, and that's in the record.
And honestly, sir, I genuinely don't know what you were referring to, because I have not seen, nor has Mr. Snead seen these allegations. However, he was adjudicated innocent in Angola precisely because the board, I believe, found material inconsistencies between what different LSP employees had said and put in their reports and what had actually happened, which I can explain to the board if given that opportunity.
I'm not going to argue with you. I'll give you an opportunity to make a statement at the end of this hearing. I'm talking to your client right now. Is there anything else you would like to say, Mr. Snead?
No, sir.
Any questions?
I have no questions.
Okay. Mr. Frampton, you may make a closing statement.
May I have the opportunity to present evidence to the board?
What do you have?
Well, at this time, I'd ask that the full record of our administrative hearing and all of the exhibits submitted therein become part of.
We're not interested in that. The hearing today is about what he did on the 25th of March that we had in our file.
Yes, sir. And again, I'd like to request what it is in that file, because I do not know what information you all received or from whom.
The admitting authorities at Lane Memorial Hospital, he injected heroin. He was tested there and he tested positive for amphetamines and methamphetamine. He also tested positive for opiates, but he was given morphine at the scene. He was not given any methamphetamines or amphetamines. He had illegal substances in his body. That's the whole purpose and point of the hearing today.
So for example, sir, this is the first instance that I'm hearing that he was injected with morphine. That negates any suggestion that the administration of Narcan had anything to do with reviving Mr. Snead, because Narcan has no effects if in fact an overdose occurs because of amphetamines or methamphetamines. It's part of the reason why I've been desperately seeking for the last month and a half.
You've made your point. If there's anything you'd like to argue or say, I'm going to give you 3 minutes to do
it. I would like the opportunity to submit to the board the records from Angola and from other exhibits related to medical records that have been given to me related to Mr. Snead. On March 25th, Mr. Snead collapsed. He is COVID positive, he's had a stroke, and he's 74 years old. On March 31st, a federal judge found that Angola's medical procedures violated the 8th Amendment because whenever somebody appears with a altered mental state, they administer Narcan and they immediately test for drugs, even though that's not indicated in terms of proper medical procedure. We've already established that there's no evidence that Mr. Snead used any kind of opium or other independent testing. And in fact, his urine testing, or what Angola purports to be his urine testing, came back negative in that regards. Now, the reason Mr. Snead was found not guilty of all charges is because, in fact, there's no evidence that the urine that was tested, that I believe the board is referring to, and I don't know if there's other medical records, but the urine that was the basis of all the proceedings was not Mr. Snead's. And in fact, there was a second set of medical records that were not disclosed, but I was able to obtain independently, that indicated contradictions between signed sworn statements from different LSP officials, specifically Lieutenant Colonel Gauthier and a Mr. Rosso. And specifically, they contradicted themselves with respect to whether or not the sample was refrigerated and who obtained the sample. There's, in fact, false statements that the samples were obtained by the guards, when in fact we learned later, subsequently, from a subsequent clarification written by Lieutenant Colonel Gauthier, that in fact somebody else was the one that provided the urine that they had a preliminary test for, which indeed I believe is what the board is referring to. But the standard of evidence at that hearing was not preponderance of the evidence. It was not beyond a reasonable doubt. It was just the some evidence standard. And despite that, the secretary's own administrative procedure cleared Mr. Snead. I'd also point out to the board, and this is a point that we've raised again and
Mr. Frampton, you've made your points. This hearing is fairly straightforward. I've listened to you and I appreciate the comments that you made. Would your client like to make a statement?
Sir, are you denying us the opportunity to present evidence, call witnesses? I would like to call these medical personnel if you're claiming. Mr. Snead was unconscious for 5 days in the ICU. I have no idea how it is that this board can say that Mr. Snead...
An opportunity to talk. We have information. This hearing is about the actions of your client on that particular day. This is a hearing to determine. He's never been released. He's not out. He's still in. This board has the authority to review its decision. That's what we are doing today.
And again, I understand that, sir.
Well, you've made your points, and I appreciate it. Anything further your client would like to say?
If I could have a moment to confer with him.
All right. So we'll put him in the room.
Can you even imagine that this is happening? Like, it's like all the respect that I have for the board, it really feels like it's going out the window in this one hearing. Do you really think that this man, remember, he just spent 44 years in prison. We just saw a parole hearing where his write-up, his most severe write-up, was for having cigarettes. You really think that he's shooting up right before he's about to get paroled? Are you kidding me? Are you really going to revoke this man who has spent nearly half a century locked up because he stood lookout for a crime that was committed 44 years ago? Are you not going to give him the benefit of the doubt that maybe Angola messed up? His attorney is putting on a fight worthy of, I am, really proud of him. And we're going to, after this, watch an interview again that Richard found from of the attorney talking about this case. It's only about 10 minutes long. I haven't seen it yet, but I am anxious to see it with you. And then there's much more to get into. But just to think, where it looks like the board is going to deny him and revoke the parole that they offer, to think that that is something that could happen is, to me, unconscionable. It's like, let's just play the game that he did. Let's just play the game that all the stress of him coming out into the world, it was a lot to handle. It's not a world he would remember. His life has been in prison, so he decided to do it. So what? Let him out. No, you'd rather make the $24,000 a year that it cost to house him in Angola? What's he going to do? He's not a threat to anyone. It makes no sense.
Ready?
I do. I believe Mr. Snead has one final moment. If the board will indulge me, I do want to make one other piece of evidence on the record, if I could.
Mr. Snead?
Sorry, for the chair, am I not permitted to put anything else on the record?
My question to you was, does Mr. Snead wish to say anything?
Yes, Your Honor. He has a very brief closing statement, but I'd also like to put one other thing on the record if the board will allow. I think I can do it in a minute.
Be very brief.
Thank you. So the other piece of information this board should know, and I'm concerned because I think it's highly improper and perhaps illegal. On Thursday night, I received a call from Executive Director Abbott, who attempted to plea bargain on behalf of the Board of Parole with me over resolving Mr. Snead's matter. Specifically, he told me that what he, quote, wanted to do, end quote, was to have Mr. Snead agree to go to Steve Hoyle for 9 months, and in exchange, this would resolve all of these matters. I hadn't spoken yet with Mr. Snead. I still haven't spoken with Mr. Snead. This is literally the first time Mr. Snead has heard this. I expressed to Mr. Abbott that I didn't think a rescission was proper without consulting with the secretary, and he said he was going to check with the Attorney General and get back to me. On Friday, we received notice that the parole board had voted and had already rescinded Mr. Snead's parole. When I called Mr. Abbott on Friday afternoon, he said, that's what happens. Mr. Snead didn't want Steve Hoyle. That's the decision. I think this is highly improper. I think the only reason we are here is because of this improper plea bargaining attempt. And it seems highly improper to penalize or punish Mr. Snead based on a decision that I was not able to communicate with.
I'm going to stop you now. You've made your points. The reason we are here is because your client violated acts by having drugs in his system and admitting that to medical personnel. So that's why we're here. Now, is there a question about him getting treatment? Absolutely. We would love for him to get treatment. That's what this whole system is about. Now, that's his choice. Because we're about to vote right now. Do you want him to speak or not? Your choice.
Yes, sir. He does wish to speak, and I would agree with the board.
Mr. Frampton, I've heard enough. You've made your points. Mr. Snead, is there anything you'd like to say?
Only thing I want to say is that I wish I could remember what happened. I don't. I don't even know how I got to Oak One. I don't know nothing. I still don't know what happened. I'm still trying to find out what happened. I was actually, I don't even know how I got through the gate. I went to 3 different gates to get to Oak One. I don't even know how I got there. I'm still trying to find out. I'm sick.
I understand, Mr. Snead. I appreciate your comments. Anything else you'd like to say?
No.
Mr. Snead, you were granted parole. 10 days later, you overdosed. You would have never been granted parole had that happened before. You have not been released. Today, my vote is going to be to deny your deny the parole. Ms. Black?
Sir, based on the documentation before me that's been presented to me to review for today's hearing, my vote is the same for the same reasons.
At this time, I'm gonna vote the same because of the reasons stated.
Ms. Russia?
Mr. Snead, based upon medical evidence from the hospital of the presence of illegal drugs on March 25th, a positive test at the hospital, my vote is to deny your parole.
Mr. Snead, I do, based on the information that's been provided today, in preparation for today's hearing, my vote today is to deny you parole. I would encourage you to seek substance abuse treatment there in Angola. They have programs they can offer you.
Mr. Snead, you received 5 votes to deny your parole. I will encourage you as well to get whatever treatment you can while you're there. Good luck to you, sir.
Yep, you just saw that right. And that's shocking. The entire board. I mean, what orders can you be under by their director, Abbott, who approached the attorney and said, well, if you just go to Steve Hoyle, huh? Let's just put some more taxpayer dollars to Steve Hoyle. Put this man there where there's no evidence that he's any type of addiction problem. Let's make him wait another 9 months through a program. And then when you don't respond in time, let's just revoke him. It's insane. It's madness. And like I was saying before, let's say he did. Who cares? But you don't think that it's possible the hospital messed up? You don't think it's possible that maybe he because like they had mentioned he had COVID, he had a stroke, he's an older man, like maybe he just got sick and went to the hospital? You know, what was interesting is he never denied, never said I never took it. He just said I can't remember. But, you know, did he think that it was the magic dragon and really it was meth? And like I just still it's, and the idea that the attorney is asking for records, asking for information, there's no and we'll go through this, but well, anyways, it didn't end here. Let's put it that way. Now I really do have about 30 articles that Richard supplied me because this was a long, ongoing process. It made the news, and quite many news outlets, which is very refreshing to see. They go through all of the work here. 47 years in prison for the parole hearing that lasted under 17 minutes, they say. You did a great job. You worked hard and all the things you needed to do, said Tony Marabella, one of the members of Snead's parole board, and informed him that he would be voting for his release. The other members also, they all followed suit and thanking him for his service. Remember, this was a Vietnam vet who has Agent Orange, who came back Snead, 74 years old. He was convicted in 1975 after returning home from war as principal to the crime for involvement in the robbery along with 5 other men in 1974, during which an elderly man was killed. But, again, he was outside. He was never even in the house. He thought he was being part of a robbery as a lookout. He was set to be released March 29th, but on March 25th, 4 days before he's set to be released, after waiting all those years, this is like a tragic movie. He collapsed in prison and was hospitalized. Someone called his family and said that Bobby has some type of medical issue. They actually thought that he was not alive, the siblings said. The Department of Corrections did not provide details about the incident, but according to Frampton, he was hospitalized for several days in an intensive care unit. At some point during that time, he was given a drug test set by the prison staff, and according to the prison disciplinary documents, it came back positive for amphetamines and methamphetamines. Snead was written up for possessing contraband in the prison. He has since recovered and has been transferred back to the prison where he's being held by administrative segregation pending. They put him in administrative segregation. What jerks! Pending a hearing that is set to take place Wednesday. Which, yeah. Then the stakes. I remind you, they found him not guilty in the hearing. By the way, the stakes are going to be whether Bobby dies in prison or gets out home and spend the rest of life with his family. Frampton said that even if Snead did have drugs in his system, this is not a reason to keep him locked up. And I would agree. Frampton told Frampton, remember his lawyer, we'll see the interview with him. Then Bobby had a medical problem, substance abuse disorder. Frampton told Lenz, we have private charities who are willing to foot the bill for 100% of inpatient drug treatment where he can actually get the help he needs. It's funny that the attorney's saying even if, right, he did it. He hasn't received over the past 46 years in prison. However, it seems that they'd rather spend $24,000 a year of taxpayer money every year until Bobby dies, not to treat a sick man who does not pose any sort of risk to public safety. Frampton is planning to be at the hearing to represent Snead. So he went nuclear, you would say, I think, before the parole hearing even happened. So he probably pissed off the board, right? Wait and see mode. The Louisiana Board of Parole and Pardons is waiting to see what would happen at Snead's disciplinary hearing. Its policy states that if a prisoner receives a disciplinary report after being granted parole, the board may choose to rescind. But remember, he didn't. He was found not guilty. Which article? It could be that it was a different article. Oh, here it is. So here's the next article. So remember, so they're saying what just happened there is that, well, if the Louisiana Parole Board won't, if they're waiting to see if they find them guilty or not. And okay. So they go through it again. They go through that information. Yet the disciplinary hearing held on Wednesday to adjudicate the matter of the charge was dropped because the committee was forced to concede that they didn't know who the drug-infused urine actually belonged to. This was after he's been in solitary confinement for a month. They put that man in solitary confinement. You can't make this up. They didn't have complete chain of custody, so there ended up being no proof that the urine samples that tested positive for the drugs was actually Bobby's. The committee immediately furnished a new charge, alleging that Snead was in the wrong dorm when he collapsed and was therefore guilty of trespassing. That charge was dropped Thursday. Can you imagine? They so desperately want to keep this man locked up that after they're proven that they can't follow that was his urine, now he's in the wrong dorm. The Louisiana State Penitentiary Disciplinary Board dismissed both charges against Bobby Snead this week. So Department of State Corrections yesterday. The parole of Snead is a decision for the parole board, an unanimous board independent of the Department of Public Safety and Corrections. So even with all of that happening, they still didn't want to set him free. Indeed, the board proceeded as if the charges for the Department of Corrections were still looming over Snead's head. We were able to rescind parole decisions when an offender has violated the terms of the decisions granted by the board or has engaged in misconduct prior to the offender's misconduct, says Francis Abbott. And if you need to see anything, if you need to know who this man Francis Abbott is, you only have to see this. This is someone who is driven by ego, who is driven by control. How can you, after everything said and done, still insist that he stay locked up? It's sick. You know, this isn't the first time that we've seen corruption by the Louisiana Parole Board. We had covered another case where they had paroled a man who did the most horrific crimes. He should have never gotten paroled. The families were never notified that he was paroled. And when he was paroled, there was a huge uproar. It was all over the news. Before he would get out, they said that they found contraband in his cell and it was rescinded. And you know, when I reported on this was back in the Louisiana Parole Board struck my channel over 60 times. Channel was at a threat of being shut down. We were all over the news fighting it, and we won. Thanks to the DUI guy for representing me. And also thanks to all of you who quickly that night came and contributed funds and moral support. But yes, this is not the first time that a parole was rescinded through fabrication. And it's disturbing. It is disturbing. And Louisiana has a track record for corruption. And I'm just going to call it out as I see it. The executive director of Louisiana Board of Pardons Committee and Parole, what was the misconduct, I asked. We've got documents that were submitted to the board that are not open to the public, he says. Now he says that we have documents that were not open to the public. Okay, well, why don't you share those documents? Frampton is among those not privy to the evidence of misconduct against his client, though Abbott did relay to him that it was a singular member of the board who upended the original decision. It's just pointless cruelty at this point, says Frampton. The parole board's latest move just shows contempt for the law, public safety, common sense, and taxpayer money. And I agree, man. The taxpayers will now be spending tens of thousands of dollars to keep Snead locked up, probably for the rest of his life. Yeah, you know what they mention here also is that out of the 6 people, he's the only one left in prison. One of them died in prison. The others took plea deals and didn't serve that much time, and because they testified against him. And the other was released on parole. So the only man left in this crime who never even stepped foot in the house is still the only one that's locked up. Now let's go watch this interview. I haven't heard of this interviewer. It's called the Clay Crane Show. He has 10,000 subscribers. Again, I haven't watched this yet. Richard shared it. I haven't spoken to him. But for the record, go check out his channel if you like what you see here. I'll put a link in the description below. With that, let's jump in.
His name is Bobby Snead. He's been behind bars for 47 years for his role in a burglary. He was supposed to be released in March of 2021, but he hasn't been released. This is a very fascinating story. I want to bring on his lawyer. He is Professor Thomas Frampton, Association Professor of Law at the University of Virginia School of Law. Mr. Frampton, how are you?
I'm well. Thank you so much for having me, and thank you for shedding some more light on Bobby Snead's case.
Thank you. So for folks who don't know, explain Bobby Snead's case.
So I don't really know where to begin because it is such a long and convoluted ordeal. But as you indicated, 47 years ago, he was convicted for serving as a lookout in a home burglary where tragically one of the homeowners was killed. So he has been serving a sentence for murder. There were 6 people involved. He's the only one still in prison. The other 2 lookouts, like Bobby, turned state's witness, never testified, and so never went to prison. The others have all been paroled or died. In March of this year, Bobby was paroled. He was allowed to live out his final years with his family. But shortly before his release, 3 days before, he collapsed. His heart stopped, and he nearly died at Angola prison. He was rushed to the hospital, held past his release date, and then instead of being paroled, actually brought back to Angola prison, where prison authorities alleged that he had overdosed, that his heart attack was the result of a drug overdose. Now, the medical records we finally got showed that when he was brought to the hospital, he had pneumonia, he had very full-blown COVID. There's lots of reasons to think he did not overdose. We actually had a trial at Angola prison. He was acquitted and cleared. But then the next day we found out they were taking his parole anyways. So we have been fighting that essentially ever since. The story gets much stranger though, because time after time we have won in court. A state court judge in Louisiana has twice granted our habeas corpus petition. The Louisiana Supreme Court has held that Bobby's constitutional rights have been violated by them sort of illegally stripping his parole in the way they did. And yet, nevertheless, he remains today in a jail cell in West Feliciana Parish in Louisiana.
Wow. That is, and so this incident happens 47 years, actually, no, it happens in 1974. And like you said, he has stood guard with 3 accomplices. A home was robbed, and ultimately one of the residents were killed in the home. But he's taken accountability for his role being a lookout. But like you said, everybody else has been released, or they have since passed away. I guess, I mean, I know you kind of broke it down, but it just seems so heinous. How is he scheduled to be released in March? It doesn't happen because they accuse him of doing drugs, whatever the case may be. How? I never heard of somebody, they're supposed to be released and they say, oh no, we changed our mind. Is this illegal? How is this possible?
Yes, it's very illegal. And I want to emphasize the point that you just raised. I mean, Bobby is not being held in prison at this point because of anything related to do with this initial crime 47 years ago. He has absolutely taken responsibility and accountability. When the parole board granted him in parole in March, they made that abundantly clear that nobody regards him as a danger to society at this point. He wanted me to emphasize that he was a U.S. military veteran. He was honorably discharged after serving in Vietnam. So this isn't a case where this is somebody who is a danger to society. Even assuming that what the parole board says is true, that he used drugs at some point this year, it is insane that we are still going to pay $25,000 a year to keep this guy incarcerated. And that number is only going to go up as his medical expenses go up because he's very sick and very old man, especially because we've offered them, look, if you think that he has a drug problem, we will get private charities to pay for any kind of drug treatment, drug rehabilitation that you need on the outside. And the state of Louisiana and the parole board's attitude in particular has just been, how dare you try to question our authority? How dare you try to suggest that everything prison guards allege isn't completely true? And they've been acting punitively against him ever since. And what's really amazing about this case is like you said, it doesn't matter how many times we've won in court. Every single judge that we've been in front of has agreed that what they have done has violated the due process clause of the 14th Amendment. And yet, nevertheless, now they're sort of trying yet again to revoke his parole. We're going to have a hearing next week where we sort of go through this whole rigmarole once again. But it's really almost Kafkaesque at this point.
I know this is a hard question to answer, but when I cover wrongful convictions, I ask this question often. But why? Why do you think? I mean, at this point, he's wrongfully behind bars. At this point, you know, he was paroled. At this point, he is wrongfully behind bars. What is the incentive? What is the reason why they want to keep him behind bars? And like you said, spend the taxpayers' money. Have they given any kind of? I know you can't get in their head, but why?
I wish I knew the answer to that question. You know, I think that there is starting to be momentum, and maybe this is just me being overly optimistic, that across the political spectrum, right, we're starting to realize that our addiction to mass incarceration in this country is serving no one. But there's just so much inertia, right? There's so much sort of entrenched bureaucracy. There's so much sense of this is the way that we have always done it. And so the idea that we would sort of suggest that perhaps, you know, lifelong incarceration isn't the right thing to do is just alien to a lot of folks. The notion that if somebody does in fact have a drug problem after 47 years in prison, maybe more prison isn't the right place for them, it is just alien to a lot of sort of the way that people think. And look, and race has a huge amount to deal with this as well. Black folks in Louisiana are approximately 30% of the population, but they represent more than 60% of the population in the Louisiana prison system, more than 70% of the people serving life without parole sentences. So you can't divorce this and what's happening to Bobby from the legacy of white supremacy and its ongoing incarnations. That's about the best that I can offer.
Yeah. Mr. Snead, let me ask you this. So he admits to being an accomplice. He didn't commit the murder, but he admits to being an accomplice. What is his original sentence? What was he originally sentenced with?
He was originally sentenced to life with the ability to have his parole reconsidered after 40 or 45 years.
Okay. So you're a lawyer. I'm going to ask you this. Was that a harsh sentence for the crime he committed? Was that over the top, or was that the sentence that one might say he deserved? I'm just curious to know if they overly sentenced him rather.
So yes and no. Yes, it's a sentence that's extraordinarily harsh, that it's grossly disproportionate to somebody's culpability. But no, not under the laws of Louisiana. Louisiana has had some of the harshest 3 strikes laws in the country. And Louisiana has more people serving life without parole sentences. It's not extraordinary that if he didn't want to snitch, if he didn't want to turn state's witness and cooperate, that they would charge him as an accomplice to a murder, especially in, you know, the early 1970s for a Black man in Louisiana. Yes, it's an outrageously harsh sentence, but no, it's not unusual or extraordinary by any stretch of the imagination.
And how old was he at the time of the crime?
He was in his mid-20s. I think he was, so we can work our way back. He actually just had his 75th birthday on Saturday.
Wow.
So he would have been, I think, 26 or so. I apologize, I can't do the math that quickly in my head. But I mean, he has spent, at this point, about a third of his life in the free world, and then 2/3 of his life in prison.
And how is he doing right now? How is he?
He had a stroke several years ago. He is infirm. He's a very smart guy, but you know, I like to think that I'm fairly smart too, and I can't understand what's happening. So you can only imagine somebody without legal training trying to make sense of this sort of roller coaster. There have been 3 or 4 times now where he was within minutes of being released, of walking out the gates, only to be rearrested or told there's been some new order in his case. The most recent one was last week. The court yet again ordered him freed. He was technically freed from Angola for about 15 seconds. And then he was re-arrested and transported to a parish prison where he is now sitting, allegedly because of the new parole revocation proceeding that they're going to start any day now. I mean, that in and of itself strikes me as a
torture. Yeah, that's torture. That's just inhumane. Wow. That's insanity. You're saying this keeps happening. Do you think he's going to be released anytime soon? What's next?
So, I mean, there's two steps that are next.
Okay, I'll cut it off, and again, I'll put the link in the description if you want to see the finish of it. But in a nutshell, he was eventually released, and it took a legal settlement leads to the release of longtime Louisiana prisoner Bobby Snead. And God bless his attorney for putting up this battle for what's right. February 28th, 2022. Basically a year ago, finally free. Bobby Snead is finally free man after spending nearly 50 years in prison and then proceeding to fight for his release after initially being granted parole. Snead, a former prisoner of Louisiana State Penitentiary in Angola, was released after the parole board agreed to a settlement in federal court. So they really fought. They fought tooth and nail. No, we are going to keep him locked up. He agreed to drop his state and federal lawsuits against the board under the terms of the settlement. Additionally, Snead 75 must also complete, they had to throw that in there, right? He has to complete a 28-day drug treatment program. It's like, if you wanted to see more proof, like we've seen it enough. We know their obsession with drug treatment programs, but they make a 75-year-old man as part of their conditions of release to attend that program. That's the definition of insanity, if you needed to see it, in my opinion. And because of that, they would halt the parole revocation proceedings, because now it's a parole revocation, because in theory, he's legally, by law, been paroled. Which doesn't even make sense. How can it be parole revocation? But it just, that there you see it. The settlement states that based on Mr. Snead's representation that he had requested drug treatment programming, his acknowledgement that he is a drug problem, and his ongoing willingness to receive drug programming, the Louisiana Committee on Parole accepted this acknowledgement and agrees to Mr. Snead's completing the substance abuse rehabilitation program as a condition of his parole. Madness. And agrees that no further revocation proceedings or adverse parole actions would be instituted against him due to any personal drug use or other non-criminal parole revocations. It's madness. According to the Louisiana Weekly, Snead was released in December following a state Supreme Court ruling. Yeah, this is what he was talking about, by the way. He was released. The state Supreme Court said you have to release him. And the parole board, Abbott, his ego was so damaged. He was so hurt by this. How could you release this 75-year-old Vietnam War veteran into the streets of Louisiana? How can you do that? So what did he do? At the gates, when he was ready to get out, they picked him up, they re-arrested him, and they sent him to a jail. So they took a 75-year-old man and they arrested him after the psychological torture that was just mentioned. But not only that, now you're moving him to a jail where he doesn't have his friends, he doesn't have his connections, he doesn't have the respect that I'm sure that he has developed in Angola, being the coach and everything that he was. No, now he's sent to a jail. Shame on you. Shame on you. Tragically, the week he was set to be released, he was found unresponsive in a prison dorm. The GoFundMe account, Richard put the GoFundMe account. It didn't get, it got like half of what it needed. Miraculously, after multiple attempts to revive him, he survived. It was assumed but never proven that he had overdosed. Thomas Frampton, associate professor of law, who we just saw, said the He has sought his release, and the possibility that his civil rights were violated would be examined. There is a possibility of forthcoming civil rights lawsuit, Frampton told Louisiana, but we have no record that that lawsuit has been filed. Just FYI. Frampton added that there was no real winners in the state's effort to keep Snead in prison after he was initially granted parole. No, there were none. In a sense, we won, but in reality, everybody lost. He said that the state of Louisiana paid over a dozen lawyers at one point to fight, and I believe it. They paid a dozen lawyers, no doubt. Mr. Snead incarcerated in a state court, in a federal court, and all of that was for naught. All of that was for pointless. All of that was for gross misuse of taxpayer dollars. I agree with every word of this statement. Frampton added that Snead is on parole and will be on parole for the rest of his life. Oh, they would love to revoke him again, wouldn't they? Snead, a Vietnam veteran with no prior criminal history, was serving prison sentence for his role as a lookout where a man was killed. He was 2 blocks away from where the actual crime occurred, but was charged with being a principal. You can't make it up. But on that note, remember how I told you about what happened with me and with our my channel and Louisiana? I figured, you know what, let me show it to you. I have it listed up on here it is on KPL TV. Also, I gave DUI guy a shout out, but also worthwhile to give the news anchor here at KPL CTV who took up this mission, who made sure to make this story public, and also to Biggin, who was one of the few that supported me few YouTubers that supported me during this situation. All the other YouTubers I reached out to ignored me. So this is the video, but I actually have it on my backup channel. If you want to, if you didn't know, I have a second channel, I should say, where I post other content. If you didn't know about that, I'll put the link in the description too. But let's go watch it.
Last week because of a contraband violation at Angola. The hearing was streamed online by the Louisiana Board of Pardons, but now they are reportedly objecting to video being shared on YouTube. Andrea Robinson has more on the dispute.
The Louisiana Board of Pardons and Committee on Parole streams all of their hearings, but doesn't publish the video after the fact. If you request them, they'll give you audio only, saying they're protecting the victims who are testifying. However, a YouTube user who goes by Mandu records the stream and adds commentary to them on his own page. It's how we got the copy we showed you last week.
I find it to be so important. Really what drives me is the idea to make transparent and to bring to the forefront how our system works, both good and bad and ugly.
After our report aired, though, Mandu says that 52 of his uploaded parole board hearings have received copyright claims and were deleted from his page, including Thomas Sisko's hearing. He had been recording the hearings for about a year without any issues.
Maybe it has something to do with the controversy behind that hearing. Maybe it didn't. I don't know.
He says this could be a violation of his rights.
We're not doing anything differently than the entire YouTube community is doing. So when I got the strike on Friday, it was like that pit in my stomach. Like, how is this even possible?
Mandu's attorney, Larry Foreman, explains that the videos on Mandu's page fall under what's called a fair use. Therefore, he says it doesn't violate copyright.
Because he is adding value, he is adding commentary, he is modifying the existing original content. As a result of that, he is allowed to keep the content. Now, the Louisiana Parole Board is saying, no, this is ours. You don't have a right to it.
Mandu's account is monetized, but attorneys we spoke with say that doesn't change his right to fair use in this situation. Scott Sternberg, who represents media organizations across Louisiana, says besides fair use, Louisiana's open meeting law makes clear the public has a right to record a meeting.
In the day of cell phones where everybody's got a camera and can take 4K or even 8K video, people record stuff in public meetings all the time, and yes, it is perfectly legal to do so.
Mandu and his attorney say they have appealed the copyright claims on YouTube.
It's when people stop fighting for their rights, it's when they get taken away from you. And
Andrea Robinson, 7 News.
Reached out to the parole board today for comment, but have yet to hear back.
So eventually, the Francis Abbott did respond back, and he made a statement which was blatantly proven to be not true, because he said that Francis Abbott, executive director of Louisiana Bowl, responded to the request for comment. Our board began broadcasting these hearings in the wake of COVID-19 pandemic to ensure the public has access to our hearings. Per board directive, the audio recordings will serve as the official record of proceedings. We distribute audio recordings of our hearings to the public upon request. It is our position that the continued sharing of the victim offender images is not in the interest of the public safety, which is our first priority. And you might say, okay, that's interesting. Well, first of all, to say it's a copyright strike was not true, right? He copied, and then after I won the first appeals, they continued to copy strike my channel. And they ended up doing it like 70 times or something, which was just, it made it so that for like 2 months I couldn't post any content. But as you know, Louisiana broadcasts all of their hearings, every single one of them, and they don't blur faces of certain victims like I do. They don't blot out private information like I do. So their whole excuse of how they're doing it and not to mention, they have a Twitter account, they have a Facebook account, they broadcast to the public before each hearing. We're doing a hearing, come check it out, to the whole world. So, but I'm thinking of maybe republishing that hearing with comment, the one that started all this mess. Like I said, it was a man who committed one of the most horrendous crimes in Louisiana. He basically wiped out 3 young children, really, in a gas station, and then claimed that he wasn't the shooter, it was another shooter, but never told, even up until this day, who it was. And there was a lot of corruption in the story, and there was sheriff's relatives and things like that. And they were still going to release him, even without him claiming who it was, that it was his accomplice. And then after they paroled him without telling the family about the parole hearing, they rescinded it by saying he had contraband in his cell. But no one's standing up for him because he's a true monster, and they shouldn't. But in this case, absolutely crazy, and you might not believe it if you didn't see it. But now you did, and thank you, Richard, for putting this together, and thank you all for being here. And I certainly do hope that those don't seek retribution out for me for doing this. But with that, I'll let you go.